too. I think that's a great plan. Good evening. Welcome to the League of Women Voters of the Palatine Area Criminal Justice presentation. I am Gail Banakis, and on behalf of my co-chair, Cami Bassick, and I, we are grateful to have you sharing in this evening's presentation. The League of Women Voters is a nonpartisan organization of women and men whose purpose is to promote the informed and active participation of citizens in government. As an organization, the League does not support nor oppose candidates for public office, but acts only on those issues chosen by the membership for study and action. One such area for study is the criminal justice reform. Tonight is our sixth in a series of presentations that will hopefully lead us to consensus in January. We invite you also to come back and join us on October 26th for a Let's Talk meeting with our League members, and on November 12th with Dr. David Olson on sentencing and incarceration. As you can see, we take this study very seriously, and we are grateful to have you with us. We, as a League in Palatine, are extremely fortunate to have Laura Davis and her team guiding us through this very complex study of the criminal justice reform. Laura has been involved for a 3-year examination of this topic, and she is eager to help us wrestle with the details. It is my privilege to turn the podium, in this case, the Zoom meeting, over to Laura Davis.
Thanks, Gail. As Gail said, I have been involved at the League of Women Voters Illinois level on working to update our current position, which is 25 years old. And a lot of things have happened since then. And the current position that we have has nothing in there regarding policing or bias or gender or investing in communities or restorative justice or criminal justice coordinating councils. So there's a lot to criminal justice. There are a lot of silos. And I thank all of you for being engaged to learn about this. And as Gail said too, once all the chapters in Illinois, League chapters have looked at the suggested position, we hope that they meet to come to consensus sometime December or January. And whatever ideas they might be offered to improve our current position or significant points of disagreement, we would like to know what those are. And they will come back to our study team to update what we've already submitted. So everyone, we're very happy to have Matt and Adrienne from the Coalition to End Money Bond. I'm going to ask you, I think we're all going to be pretty much on mute. And if you put your questions in the chat box, we're going to allow about an hour for the presentation and then have about 10 to 15 minutes at the end for questions. And I thank you all for being here. So a little background here. Matt McLaughlin is an activist and a legal worker. He's a founding member of the Coalition to End Money Bond and currently serves as the Director of Programs. He cut his teeth as an organizer with Occupy Chicago. Matt went on to organize around school closures, immigrant rights, and racial justice. For years, he has helped lift up, document, and support local and national social movements.
I'm reading that right now. Very good. I just started reading that.
Lee, can you?
Yeah.
How does it go? Does it go? Does it flow?
Yeah, well, like, I mean, I really am like on the first chapter.
I just muted everyone. Oh, Laura, unmute yourself. Unmute yourself.
Okay, can you hear me now?
Yes.
Okay, good. So for years, Matt has helped to lift up, document, and support local and national social movements, including organizing jail support and solidarity actions. Matt also works with the National Lawyers Guild, Chicago chapter, as the Mass Defense Coordinator. And Adrienne Davis is the newest staff organizer with Southsiders Organized for Unity and Liberation, also known as SYLE. Prior to finding a home base with SYLE, she spent 3 years with Black Lives Matter Chicago and worked on campaigns around police violence and torture and police divestment, most notably with the No Cop Academy campaign to steer $100 million from police back into the west side of Chicago. She now does very similar work around divesting money from Cook County Sheriff and jail, coupled, of course, with the work to end money bond. Thank you very much. And you guys, do you want to get started and share your screen, or however you want to proceed? Have to unmute.
Sure. Thanks for having us. I am going to share my screen. Let me know if you don't see anything. Can everyone see?
I can see it.
Awesome. So yeah, as stated, we are a part of the Illinois Network for Pretrial Justice, and of course the Coalition to End Money Bond. And I'll let Matt kind of explain, you know, Matt really was at the ground level for a lot of this work, and as I'm very new with SYLE into this work, I'm gonna let him dive in.
Hey.
Cool. So yeah, we are, thank you, Adrienne. We are part of the Coalition to End Money Bond, which has been organizing to end money bond and dramatically reduce the number of people incarcerated in Cook County for the last several years. And we are also a part of the Illinois Network for Pretrial Justice, which is connecting organizations from Chicago to Carbondale, working on this issue. And in particular, right now, we are engaged in some legislative work. And tonight, we're going to go over a little bit about how money bond works, why our organization believes there is an urgent need for bond reform in our state, the harms that are caused by pretrial incarceration, the steps we believe the state could take to create a fairer pretrial justice system. We would really flag that ending money bond is really just the tip of the iceberg of the changes that need to happen. We'll talk a little bit about some of the negative developments or things that we believe could happen to our pretrial justice system in our state, and then give you all a few ways in which you can get involved with this work if you are inspired by what you hear tonight. And so to kick us off, we're going to just, I guess, describe what bond is. And so I think when most people hear about bond, their first thought is the exchange for money for somebody's pretrial freedom. But the reality is that money bond is actually one of just many different forms of bond in Illinois. And so when people are talking about bond, they're really talking about the conditions that somebody has to meet in order to maintain their freedom pre-trial. So again, most commonly people are thinking about having to put up a certain amount of money to secure somebody's freedom while their case is pending. But conditions of bond can also include things like drug testing, checking in with a pretrial services officer, potentially being on an electronic monitor with house arrest, really anything that they have to do in order to stay free. And one really important thing that we always try to highlight is that when a judge sets a bond, they've made a release determination. So they've decided that if this person puts up this amount of money, or if they attend these drug tests or meet with that pretrial services officer, that the judge believes that that person is safe to return back to the community. They believe that that person is not a flight risk. In Illinois, a judge does have the ability to deny somebody their pretrial release, so they don't have to set a money bond at all. They don't have to set conditions of bail. A judge can make a decision that somebody's not safe to return to the community, or they believe that they'll flee. So the argument is that we make is that if a judge has gone to the step of setting a dollar amount, at that point, the only thing that's keeping that person incarcerated is their access to wealth. So the size of somebody's bank account is literally being the main determination as to whether or not somebody's returning back to their community. while their case is pending. And we think it's really important to note that throughout Illinois, in many jurisdictions, bond money doesn't actually get back to the people who've put it up. So in theory, when the case resolves, if the person has made it to all their court dates, they followed all the orders of the court, they're supposed to get that money back. In many jurisdictions throughout the state, counties are taking large amounts of money in the way of fines and fees from our most marginalized residents. And so it not only is it wealth deciding who's getting out, it effectively also becomes a wealth tax on people's pretrial freedom. So in many cases, it's money that these families will never see again, which I think is also another important note, is that, in a majority of cases, it's not the person who's been accused of a crime that's being forced to pay the bail. It's their friends, family, and loved ones who are having to come up with that money in order to secure that person's freedom. And so in a lot of ways, I think it could be argued that money bail is actually destabilizing these communities whose safety that we're concerned with. And I think we all know that when people are financially precarious, they're not in as safe of a position as they could be. So we can move to the next slide, and I think I'm handing it over to you, Adrienne.
Yeah, so, as we are having these conversations around, punitive and carceral systems, there is an urgent need for bond reform in Illinois. More than 250,000 people are incarcerated in jails across Illinois every year. 90% of them are pretrial, which is much higher than the national average of 67%. A majority of these people are incarcerated simply because they just can't afford a money bond. So, obviously, as Matt spoke on earlier, this is a wealth-based punishment inflicted while people are still presumed innocent. If these individuals had more money in their bank accounts, they'd be at home, they'd be able to work, supporting their families and other loved ones and making positive changes. The presumption of innocence really is supposed to be the bedrock of our criminal legal system, right? So in Illinois, it is only available to those who can afford it. And that's just not right. Many of the people who lose their freedom pre-trial will never be convicted of anything, but they were punished before that was decided. So, we'll have a story soon about, I'm sorry, going too quickly, the harms of pretrial incarceration. But we are working to end money bond because of the harms caused by pretrial incarceration. Across the state and the country, unaffordable money bond are the main reason people are locked up in local jails. Incarcerating someone pre-trial has significant consequences on the rest of their life. Just a few days in jail can cause people to lose their jobs, housing, even custody of their children. And, after a month in jail, people start to lose access to crucial public benefits that they were receiving, creating gaps in coverage for things like healthcare and social security benefits after they're released. Just 1 or 2 days of pretrial incarceration can significantly disrupt a person's life and set off a destabilizing domino effect. The first few days, are also the most dangerous because many people die in jail within the first 5 days. Death is a particularly high risk for the most vulnerable, including people with mental health needs or people with addiction. And, we're also in this moment where we've Cook County Jail during the COVID era has claimed 7 lives, unfortunately.
Adrienne, excuse me for interrupting, but you're coming in and out with the microphone. Some words are clear, some words are not. Is there something you can do with the microphone? Sorry.
I might just have to be a little closer. Is this a little better?
Yes.
Okay. I have a very deep voice, so I apologize. It's it's like whispers in the dark always. But the next, we're actually going to hear a story from Matt about Lavette. And I don't know that we won't have the video, but Matt, if you don't mind taking over for just a second to tell Lavette's story.
Yeah, no problem. So yeah, typically at this point, we would share a animated video that was made by the ACLU of Illinois about a woman named Lavette Mays, who was incarcerated in Cook County Jail for 14 months because she couldn't afford to pay her bond. Lavette is the mother of 2 children, and because of her pretrial incarceration and her unaffordable money bond, she actually lost her business, she lost her housing, and almost lost custody of her children. Fortunately, the organization I work with, the Chicago Community Bond Fund, was able to work with her family to bond her out of Cook County Jail. And then she spent close to a year on house arrest with electronic monitoring before she was able to put this case behind her. But, you know, I think a lot of the times you know, the news media will create narratives about the kind of people that are being impacted by jail. And I think it's really important to remember that it's not just the people who are being incarcerated, it's their entire families and communities who are being punished before somebody's even been convicted of a crime. You know, her children were separated from her for over a year for a case that ultimately was resolved with much less punishment than what she had gone through while her case was pending. And so I think the video is really worth watching and hearing Lavette's story in her own words. So I'll make sure to drop that in the chat. That way, if folks want to take a look at it after our presentation is over, you can hear her story in her own words. But, you know, every year, over 60,000 people are passing through Cook County Jail, some 250,000 people through our jails across the state. And I just think for a minute, if you put that into perspective, that each of those people has probably at least 3 to 4 people in their community that they're connected to, that they're being pulled from. The harm is really enormous that it's having on our communities across the state. So I'll hand it back to you, Adrienne.
Yeah, and I mean, I think that really speaks to why, you know, obviously pretrial freedom matters. Being incarcerated pretrial makes it harder for a person to participate in their own defense. People in jail are more likely to be convicted, and they serve longer sentences than people who are free awaiting trial. This is obviously unfair, and, you know, the main reason people are locked up or are not free is because of how much money they have. The pressure of pretrial incarceration can lead to someone accepting a plea deal simply to get out of jail, a deal that they might not have taken if they were able to maintain connection with their friends, family, and community. The irony is also that many people who are jailed pretrial are immediately released after conviction on probation or because they have served their time already. So that also means that the state doesn't really believe that they are a safety risk. Can folks hear me? Am I better this time?
Yeah.
Okay.
Thank you.
The pressure of pretrial incarceration can lead to someone, I'm sorry, getting ahead of myself. Locking people up who are presumed innocent is also undermining the system's own stated goals of creating safety and ensuring people come back to court. People who are in jail pretrial are more likely to be rearrested in the future. That means jailing people is literally creating more crime. This makes sense when we think back to all the negative impacts of jail and how, you know, the impacts that it has on someone's life and how it keeps them from maintaining positive relationships or staying connected to resources that help them succeed. The less we destabilize people by jailing them and is obviously better, and instead support them with resources in community, you know, that'll make us all better. And I will hand it over to Matt.
All right, so I'm going to explain basically how our current pretrial justice system works in Illinois. So obviously the entry point to the justice system is through an arrest made by the police. At that point, a charging decision is made. In most instances, if somebody's charged with a misdemeanor, in Cook County at least, they're being released directly back to the community without having been in front of a judge. Some misdemeanors, the person will be taken to bond court, and then all felonies, the person is transferred to bond court. where they appear in front of a judge, and that judge can basically make one of 4 decisions. So the first is the judge could decide that somebody's getting what's called an I bond, which refers to a recognizance bond. And that basically means that the judge has determined that the person can go back to the community without having to pay any money at all. The second thing that could happen is the judge could decide that they're not going to set a bond, that they believe the person is too dangerous or that they present a flight risk, and they will not allow them to be released pre-trial, which means that for the duration of their case, which could last up to 1 to 2 years, that person will be incarcerated until a judge makes a finding of innocence or guilt at the end of the case. And then the third avenue is that a judge decides to set a monetary bail. And then if that bail is unaffordable, again, that person could be incarcerated for up to 1 year to 2 years simply because of the size of their bank account. And then in some cases, a person is either able to afford the bond or their friends and family are able to pool money together, or in some cases even sell resources like cars or put a lien on their house in order to come up with the money in order to secure a family member's freedom. In Illinois, money bonds are typically issued in the form of what's called a D bond, which is a deposit bond. Illinois is actually one of 4 states that outlawed the bail bonds industry. And that happened back in the 60s, but during the civil rights movement, there was actually a wave of pressure for the U.S. to reform its bail system. And Illinois was one of the only states that took a proactive step. So fortunately, we don't have the predatory bail bond industry here. And that's why typically you'd hear a judge may say somebody has a $30,000 D bond. And so the person, in order to secure their freedom, has to pay 10% of that bond in order to be released. So instead of paying a bail bondsman and then owing them, installments or accumulating interest, you're just paying a deposit on your bond to the state of Illinois. And we can go to the next slide. And so our coalition would argue that, this system is not making our community safer, and that we are needlessly destabilizing people's lives and denying them their freedom, again, simply because of the size of their bank account, not because they're a danger to the community, but because of how much money they have access to. In many parts of the country, the bail system has been found to be unconstitutional. There's civil rights lawsuits that have challenged the constitutionality of money bail that have been filed around the country. And in many jurisdictions, they've been successful, or those lawsuits have created pressure to create change. So here in Cook County, we had a order put into effect by the Chief Judge, Timothy Evans, back in 2017 called General Order 188A that contributed to dramatically reducing the number of people incarcerated pre-trial here. And that was an indirect response to litigation around the constitutionality of bail. And more than anything than just the idea that the system is unfair, several states have already shown that reforming our pretrial justice system works. So if we can move to the next slide. And then if you don't mind clicking through here, Adrienne, there's some stats I think are going to come up. Whoop.
There we go.
Yeah, so like I said, there are several jurisdictions that have either eliminated money bond or greatly reduced its use, including right here in Cook County. And I think the most notable thing about the changes that have already taken place in different parts of the country and here locally is that we've been able to grant more people their pretrial freedom, eliminate money from the equation, and have not endangered communities by doing so. And actually, even here in Cook County, bail reform has coincided with an overall reduction in crime. And so in Cook County, between October of 2017 and December of 2018, of the 42,000 people that were released pre-trial, only 257 of them were subsequently arrested and accused of committing a violent offense. So that's literally 0.6% of people who were released pre-trial. And many of those people in that 42,000 would have been locked up previously. So Cook County Jail, when these reforms went into effect, had about 8,500 people in the jail on any given day. And that's fortunately dropped down to about 5,500 people. And New Jersey implemented bail reform, and there's basically no use of money bail anymore in Illinois, and they've seen an overall reduction in the number of arrests made since bail reform went into effect. And as Adrienne had talked about previously, you know, with getting rid of the money bail system and granting people their pretrial freedom, there's a reduction in the number of people being sent to prison. People are serving less time and are less likely to be arrested in the future. And some people, I'm sure, are curious as to why that is. I think we would argue that people who are released pre-trial have greater resources to actually fight their case in court. They also don't have the pressure of being in jail pre-trial. I think, you know, if anybody's ever been into a jail to visit a friend or family member, you know, or spoken with anybody who's ever been incarcerated, jails are a horrible place for people to be. There's a ton of pressure on people to accept plea deals just to make their cases end. You know, like I said before, you know, somebody could be incarcerated for 1 year to 2 years just waiting for their case to resolve. And when you're in the conditions that exist in most county jails, the pressure to take a deal in order to get back home to your community is much greater than when somebody's on the outside. So in addition to being an important pretrial justice reform, we would argue that ending money bail is actually like the first step to really addressing the problem of mass incarceration. We could go to the next slide. And so I'll drop a link to this report in the chat, but our coalition has organized around what we call the principles of bail reform, which are listed here, and wrote a report a year ago called The Vision for a Just Pretrial System in Illinois that really lays out the things that we think would need to happen in our state in order to make the system fairer for people who are arrested and charged with crimes in Illinois. And we're going to go through what those recommendations our coalition has made are and why we're making them. And so we can go to the next slide. And like I said, I'll drop a link to that report in the chat. So at the forefront, obviously the Coalition to End Money Bond believes that we need to end money bond in Illinois. We're also very excited that this afternoon, Governor Pritzker outlined his 7 priorities for reforming the criminal justice system in Illinois, and actually ending money bail was at the top of that list. We believe that creating a fairer pretrial justice system starts with abolishing the use of money bond in the state. Wealth incarceration, we believe, should be a thing of the past, and people should only ever be jailed after they've received a robust hearing that really reflects the seriousness of the decision that's being made. You know, in Cook County, about 4 years ago, the average bond hearing was lasting about 30 seconds. So when Levette, who I mentioned earlier, ended up spending a year and 2 months in jail on an unaffordable money bond that she said she was, I believe, 42 when she walked into bond court, had never been arrested before in her life. And she goes to this bond hearing, and in less than 42 seconds, so less than a second for every year she'd been on this earth, a judge made a decision that ultimately changed the future of the rest of her life. And so, you know, we really believe that if we're going to be locking people up pre-trial, that needs to happen only after there has been a robust hearing and that a determination has been made that, you know, locking somebody up is the only way we can keep our community safe. And that money should never be the thing that's deciding whether or not somebody gets to go home to their family. Pass it over to, or actually I think I'm on this one too, sorry. So direct release from police custody. This is really important because right now in many parts of Illinois, the police don't actually have the jurisdiction to release people from custody. They have to bring somebody in front of a judge before they even let somebody go home. In Cook County, most people who are charged with a misdemeanor are taken to a police station. The police charge them. They give them their next court date. They get paperwork, and then they're discharged to go home to their families and then have a responsibility to show back up in court. There have been many studies that show that the worst impacts of jail happen after the first 24 hours, including the risk of rearrest or missing future court dates. And so in our opinion, that means it's critical in terms of keeping our community stable that we get people out of custody as fast as possible before that destabilization takes place. And so we would argue that a majority of people who are arrested should be eligible for release from police, directly from police custody. And that means that, you know, they should not be held for long periods of time before being able to see a judge. Yeah, that people should just be given a summons and the opportunity to come back to court. And we can move to the next one. And this is you, Adrienne.
Yeah, so I mean, to really like harp on it, people need resources, not surveillance and monitoring. Right now, most pretrial conditions are punitive and create a higher likelihood that a person will be reincarcerated while fighting their case. They create rules that people cannot succeed under, and the more rules that are applied, the more likely someone is to fail to meet them. The pretrial justice system should ensure people receive real support services while they're fighting their cases. This means providing people with what they need to get to court, such as bus passes or Uber rides, offering flexible court dates and rescheduling, and connecting people with voluntary services in the community. Accessing services must not, however, become a condition of release that people are punished for not doing. We do not want pretrial services to become a way that the courts get control over more parts of people's lives, such as healthcare, childcare, education, jobs. Oops, sorry. So we know that the current pretrial practices are harming people across the state, but we don't have good information about what exactly is happening in Illinois in the 102 counties that are in Illinois. What is happening in bond hearings and jails across the state is not currently being tracked. That means there is no meaningful oversight as to whether or not people's rights are being violated, or even who is in jail and why they're there. Any reforms passed by legislature should require counties across the state to collect and publicly release data on what is happening in courtrooms and jails across Illinois. Any reforms, data collection provisions will be essential to ensuring that reforms are properly implemented.
Adrienne, move closer again, please. Thank you.
Okay. So data collection provisions will be essential to ensuring that reforms are properly implemented. It is what will allow us to ensure fewer people are jailed and that counties don't just replace money bond and incarceration in jail with incarceration at home or electronic monitoring or other punitive conditions. So I'll talk about missing court as well. So currently missing a court date means reincarceration. This policy provides no incentive.
Adrienne, I'm sorry to interrupt you, but I don't know what's going on with the microphone, but it's like really, really choppy.
Okay, maybe take over for this next slide and let me figure it out.
Okay, yeah, no problem. Sorry, I know you obviously can't hear how your audio is cutting across. So yeah, missing a court date. So currently in Illinois, missing a court date means reincarceration. By default, a judge is issuing a warrant to order that somebody is brought back in, and that's going to mean going to jail. The current policy, the way it's structured, really provides no incentive for a person to return to court if they've made an honest mistake, like forgetting a court date or having encountered a reasonable barrier to making it to court, like having a car accident, a breakdown, missing a bus. Maybe all of a sudden you find yourself without childcare. You know, right now, if you've missed that court date, simply by re-engaging the legal system, you're at risk of being taken back into jail. We believe that courts should give people who've missed a court date a 48-hour window to come in before issuing a warrant. So people should get a notice through a phone call or email that's a reminder that they have missed their court date, and that, you know, sending out things like a court reminder is also much cheaper than sending officers out to take somebody back into custody. You know, like we've mentioned before, in some parts of the state, felony cases can take 1 year to 2 years to resolve. This literally means traveling back and forth to court, sometimes, you know, once a month for that duration of time, which means, you know, scheduling childcare, getting a day off of work, just so that you can get back and forth to court, which, you know, can become very difficult to have to explain to your employer once a month that you're going to need to change your schedule. We want people to do the right thing and return to court, but they often face real barriers, and allowing people who just missed a court date to come in will make the courts more efficient and prevent people from being jailed over simple mistakes or access barriers that are caused by poverty. You know, one really, I think, great example of how difficult it can be for some people. Our organization, the Chicago Community Bond Fund, paid bond for a young woman a few years ago who was arrested up at Clark and Division. And due to overcrowding at 26 in California, Cook County's main courthouse, they placed her case in Skokie. This young woman was 18 years old and lived down at 111th Street. And so by taking public transit, she was forced to do a 3-hour commute on CTA just to make it back and forth to court. And fortunately, she got through her case without any problems. But, you know, the likelihood that she could have missed one of those transfers, and just like, I think in terms of like, you know, we're talking about a young person's first interaction with the justice system, you know, they effectively made it as hard as possible for her to make it to and from court. And yeah, you know, the punishment of having missed a court date being, you know, we're going to lock this person up without asking any questions, we believe is something that needs to change. And we can go to the next slide. And I think I'm back on. So yeah, there's a lot of people talking about bail reform right now. You'll hear advocates and impacted communities say that Illinois needs to reform its bail system. And then you'll even hear people in law enforcement saying that changes need to be made to the pretrial justice system. Not all of us mean the same thing. We believe that reforming our pretrial justice system gives us an opportunity to dramatically reduce the number of people who are incarcerated in jails and prisons across our state. But we believe that if these reforms are not done properly, it could cause the exact opposite thing to happen. And we could see reforms that actually lead to an increase in the number of people who are incarcerated pretrial in Illinois. And so we're going to spend a little bit of time talking about some of the things that we believe need to be guarded against in making changes to the legislative process. Some of those things being risk assessment tools, false alternatives to incarceration like electronic monitoring, and exemptions that leave people out of reforms. And so risk assessment tools, you know, are currently permitted in Illinois and are already in use in several counties. They're heavily relied on by system actors who want to move away from money bond. And our coalition has a lot of concerns about risk assessment tools. And we believe that we need to actually limit their use and reduce the harms that are caused by them by creating protections for accused people if a risk assessment tool is used. And so want to explain a little bit about how these tools work. Risk assessment tools were actually originally put in place because they wanted to reduce the chance that judges were making release decisions based on their own biases. The problem is that we have found is that risk assessment tools have their own biases built in. So you'll see some of these, the text on this slide are headlines from different news articles, but there's questions here like, are criminal risk assessment scores racist? Computer program that calculates prison sentences is even more racist than humans study find. So the idea was to create this computer tool that would be supposedly non-biased in making decisions. The problem is that these tools are inherently problematic as they're based on people's criminal records, which we know start with racist policing practices, and stats around criminal records contain massive racial disparities. So in a lot of ways, the tools are measuring the criminal justice system's response to a person and how they look, where they live, rather than anything about that person. One thing we often talk about is that the zip code a person lives in will often dictate how many interactions they have with the criminal justice system. My favorite example is if you go down to Wrigley Field, where the Cubs are playing on a game day, you'll see people drinking in public on the sidewalk, people riding their bicycles on the sidewalk, maybe folks are betting on the game. Most of those people are not going to wind up with a citation or getting arrested, but in different parts of Chicago, all of those activities could result in somebody being taken into custody. And so, just depending on where you live really can dictate how large of a criminal record you have. And the decision-making practices of judges have been shown to be subject to implicit racial biases, classist, and otherwise can be often problematic. But that doesn't mean that we should rely on a risk assessment tool that launders that bias into something that is supposed to be objective. We would argue that the policing data that is being put into these algorithms is in a lot of ways garbage. And so if you put garbage into a system, you're going to get garbage out. In California, they've actually just passed a bail reform law called SB 10 that it actually makes risk assessment tools the primary release decision for all charges. We think it's really important that if Illinois does undertake reforms, that we don't allow the risk assessment tool to be the only thing being taken into consideration. While judges have their own biases, we believe it's important that we're considering other factors that can't be captured by a risk assessment score, like what a person has going on in their life, their commitments, and all kinds of other circumstances that aren't going to be found by just looking at somebody's criminal record. Adrienne was talking earlier about transparency. In a lot of cases, there's not very much transparency about these tools and what data is being used to calculate the scores, what things are being factored into those decisions. And if somebody's pretrial freedom is on the line, we think it's really important that defense attorneys have access to whatever information it is that is informing whether or not a person may be released back into the community while they're fighting their case. And I'll pass it back to Adrienne.
So yeah, I mean, just to kind of add like another layer to all of this, we'll talk about false alternatives to incarceration. And, many are obviously at this moment being offered up in response to calls for, alternatives, especially during this COVID era. And really at the forefront is electronic monitoring. So electronic monitoring is not actually an alternative to incarceration. It is an alternative form of incarceration. Electronic monitoring in people's homes moves the jail into our communities and turns homes into cells. The restrictions of electronic monitoring are incredibly severe and can cause serious harm for individuals on it and their loved ones. People on EM are routinely denied the ability to go to work or are given restrictions that make it impossible for them to go to work. The restrictions can also be so serious that people are unable to leave their homes to go to the grocery store or the laundromat. People are regularly prevented from going to the doctor or even taking their kids to school. So, you know, we would like to see the elimination of EM, electronic monitoring, in the long term. In the short term, we can add some important protections and lessen some of the punishments that coincide with EM, electronic monitoring. There should be a guarantee that anyone subject to house arrest and or EM receives credit for that time toward any future sentence. This is only sometimes happening right now. It also reduces the penalty for EM escape violations from a felony to a misdemeanor, and removes mandatory consecutive sentences for cases acquired while out on bond. Many counties in Illinois do not currently have pretrial electronic monitoring programs, but they may try to start them if they can't jail as many people on unaffordable money bonds. We really must work to prevent this, and data collection provisions should ensure that we monitor how many people are on EM and help us track this. People can work in their individual counties to oppose creation or expansion of electronic monitoring or GPS monitoring programs and demand no new investment in these pretrial surveillance systems. So yeah, if fewer people are in jail, the county should take the money from the jail's budget to do anything else it needs, not get more money on top of that. So I'll just drop a couple things here. So a lot of elected officials will ask about bail reform for people facing non-violent charges, especially centering people with drug charges. Our vision includes everyone, so it's important that we don't leave out people who are accused of more serious things. All people are deserving of their pretrial freedom, regardless of the accusations against them. At the foundation of our criminal legal system is the principle that we are all supposed to be considered innocent until proven guilty, and that applies to everyone. We do need to wrestle with the discomfort we have around releasing people charged with more serious crimes, as caging them is in direct contradiction with this principle. Currently, we are locking people up sometimes for years at a time, simply because of an accusation. This is destroying lives, tearing apart communities, and today our system treats people as if they're guilty until proven innocent, and that's just not right. And that approach is not making us safer. As we talked about earlier, jailing people destabilizes their lives and makes it more likely that they will be rearrested in the future. Jail is isolating, it's violent, it's a violent place that traumatizes and re-traumatizes people. People do not get help in jail, and the shame, stigma, and the hurt it causes can even increase the likelihood of future violence. Just because a person has been accused of a crime doesn't mean they're a danger to their community. The court currently has the ability to deny people pretrial release if it can be proven that a person presents a real risk to the community's safety. So while it's easy to focus on a few horror stories, the truth is that people are not a threat to their community. After Cook County doubled the number of people released on pretrial without paying money, just about 1/2% of the more than 30,000 people released in the last 2 years have been accused of committing a violent crime while out on bond. Meanwhile, 99.4% of people successfully and safely returned to their communities. So reforms to the pretrial justice system should ensure that judges cannot say that someone is a general threat to public safety. Instead, the judge must conclude that someone poses an identifiable threat to a specific person, and the evidence they consider must be clear and convincing, which is just a way of making sure the proof is good and the standard for taking away someone's freedom is higher than it is now. So I will pass it to Matt to talk about how we can all dive in and help. Sorry.
So this slide unfortunately is outdated. But actually, if you want to just, you can take us off the presentation actually, if you want, Adrienne.
Sure.
So yeah, right now the Coalition to End Money Bond is very focused on trying to pass legislation that'll address a lot of these different issues. I'm dropping a link in the chat if folks want to take a look at a later time to our website that has information about the legislation that we're currently supporting on this issue. And if you're interested in learning more about pretrial justice in Illinois and the reforms that we're working on, there are a series of town halls coming up later this month that are being hosted by different representatives, along with Senator Robert Peters, who's proposing the legislative changes. So those are two great ways to learn more about what's happening right now, because there is a lot of activity around the state to try to address these issues. And yeah, that is really the end of our presentation. I can drop my email in the chat if folks have further questions that we don't have time to address or that you think of at a later time in relation to the presentation that we gave tonight. But I believe we have time for Q&A, right?
Okay. Yeah. Thank you very much, Matt and Adrienne. You know, listening to what you've described, and our criminal justice system is based on innocent until proven guilty. The data shows that people do better if they're not thrown in jail. They don't lose their jobs. They don't have their car towed. They, don't lose their apartment. And we treat people more humanely. Why wouldn't everyone want us to only keep the people that are flight risk or dangerous to the community in jail? What's the pushback?
And sorry, were you kicking that as a question to us?
Yeah, I am. Who fights it?
Unfortunately,
I got asked this the other day, by the way, so.
Yeah, I mean, I think a lot of the times we hear these arguments from law enforcement that unfortunately I don't think have enough respect for the legal system as it's been set up. You know, we're supposed to have rights that are respected before we take away somebody's freedom, and that obviously before conviction. But ultimately we have a robust trial system that people are supposed to go through before they're punished. And unfortunately, I think there's just too many people out there that want to equate an arrest with a finding of guilt. And I think like the information that Adrienne shared in that last slide, I think is really important, and that we need to wrestle, with the fear that I think is pushed on us by a lot of local media reporting. If you turn on the nightly news, it just feels like we are drumming up fear in people about our neighbors. And yeah, I'd say it's a lot of pushback from law enforcement in terms of not wanting to grant people their pretrial freedom.
Okay, so I have a couple of people that are here tonight who are involved in our next, what we call our Let's Talk, which is geared toward our league members. Melissa, if I can unmute you, or maybe Cammie can unmute Melissa Hutchinson and she can ask the question.
She can unmute herself.
Melissa, can you unmute and ask your question?
Yes. My question is really, it's not even so much a procedural thing, like you could stop doing this and start doing that, but it seems to me that especially with Chief Judge Timothy Evans' decree, for lack of the proper term, that you could not use, that you can't have money bond unless a person has the ability to pay that money bond, has been in place now since 2017. But by your own website, it says that that is not happening with all of the judges. How do we get the court system to use the tools that are allegedly in place?
So the issue with the order that Judge Evans put down is that a general order from the chief judge of the county almost acts as like a recommendation from your boss, and doesn't have the same power as like a change in the law or a ruling from the court. So effectively, the joke I always make is be like your boss telling you, look, if you wear pink shoes to work, I'm not going to fire you, but I'm going to give you a really hard time every time you come in. And you can choose whether or not you're going to wear the pink shoes and put up with the hard time you're going to get. And so unfortunately, the only thing that Evans as the chief judge can do to hold the judges accountable in Cook County to his order is rotate them into different parts of the court. And so, he's effectively can't put all the criminal courtroom judges that disregard the order in traffic court. And the other problem is Judge Evans is elected by his fellow judges. So if he goes too far in trying to hold them accountable to this order that he's put in place, we believe that he's reasonably backed into a corner, that there's only so much he can do. So I think the main focus has been trying to get judges in Cook County Central Bond Court that want to adhere to the order and believe in its importance and believe that it's actually, more respectful of people's constitutional rights than what was happening in bond court in 2016, 2015. But even there, we routinely see judges setting bonds and amounts that people can't pay. And actually, right now is a great time to be able to see it for yourself because of COVID with the courtrooms being shut down. Cook County Central Bond Court is live streamed over YouTube every day. So, you could go to the Cook County Criminal Court's website, and I can drop the link for that in the chat in a second here. But you can go and watch, and you'll literally hear the judge asking people, how much can you afford to pay? Somebody may say $500, and then the judge will come back with setting like a $2,000 bond. And at that point, the judge knows that they've effectively made a detention decision by setting the bond higher than what that person could afford. So in terms of making them adhere to these changes, we've talked with civil rights attorneys about trying to file further litigation here in Cook County and other parts of the state. Immediately after Evans's order went into effect, our coalition worked with groups across the state and stakeholders to write letters to the Illinois Supreme Court, basically suggesting that the Supreme Court of Illinois step in and set a Supreme Court rule that mirrored the one that Evans wrote. And that would have been something that attorneys could have used as leverage to hold judges accountable. And actually all of Cook County's major stakeholders, so the public defender, state's attorney, even the sheriff, all wrote letters to the Supreme Court of Illinois requesting that they step in. Even former Attorney General Eric Holder wrote a letter along with us asking for that change. Unfortunately, the Supreme Court of Illinois decided instead to set up a commission that was running for the last 2 years that was looking at Illinois' pretrial practices. And it was made up of judges, public defenders, state's attorneys, law enforcement, trying to see what, if anything, needed to change with our system. They actually agreed with a lot of the things that our coalition has been putting forward, including they recommend that the state does need to bring an end to the monetary bail system. Unfortunately, they did not give like a recommendation as to how they thought that should happen. So they didn't back up the call for the Supreme Court rule. They basically have left the decision in the hands of Springfield right now, where they could pass legislation that would accomplish that. And so I'll drop a link to the bond court viewing in the chat. And then I'm also going to drop a link to a report that we just put out back in April that was in response to the Supreme Court Commission report that, talks about the changes that the court brought up and where we see similarities in our positions.
Okay, so then I have a follow-up question, that if we were to end the money bond and we were to stop detaining people pre-trial, it seems to me that would create a lot of time for your court employees to actually take each case individually. But it sounds to me like that would be sort of a suggestion from my boss and no way to really, I guess do we have to get that coded and codified so that it will be adhered to, or is it just something that we're hoping would be a positive outcome from changing these things?
I'm not sure if I understood the question.
I guess the question would be if we can free up the time, because it seems to me that if you're going to have the cash bond and you have the pretrial detention, that takes a lot of resources, a lot of human beings doing jobs, that if we don't have that anymore, we still have those people who have a job and they have to have something to do. So do you feel that they would then be spending time with not just your risk assessment, but also the individual, considering each individual case, or do you think it would just be that we'll move more people through the system?
So I think actually, you know, like I had mentioned, the bond hearings in Illinois right now last like a minute to 2 minutes in most parts of the state. And so within that short period of time, they're making a decision that has a dramatic impact on that person's life, but also the likely outcome in their case. With the legislation that we've proposed, the Pretrial Fairness Act, we believe we actually have to have a much more robust hearing that happens at that initial bond hearing. And so we think that public defenders and private attorneys need to be given a greater amount of time to prepare for those hearings and to be able to actually present real mitigation material about that person, about the facts of the case, and actually have time to really review the allegations. You know, in many cases, a person is transferred from police lockup to a county courthouse at like 6 or 7 o'clock in the morning. They maybe talk with a attorney for 10 or 15 minutes. And if you watch bond court, like I was suggesting, you're gonna, by the end of it, you might feel like you could deliver a bond defense. Because the same arguments are brought up, you know, oh, lifelong resident of Cook County, this job, this many kids, and then hoping that the judge is going to take sympathy on the individual. But, you know, real questions about the facts of the case. And again, I mean, oftentimes it's just the state's attorney's office having the opportunity to read off the police report without a defense attorney actually having time to provide mitigating information to what they're going to hear about what the police are alleging. And, you know, just because somebody's charged with a serious crime doesn't actually mean that they've harmed anybody. And yeah, I think we really need to step back and, you know, recognize that there's a reason we have a criminal legal system, and it's set up to make sure that people's rights aren't being violated. Unfortunately, right now we're acting way too quickly, and folks' rights, I think, are being violated across the state. Somebody asked, I'm dropping a link now to the Illinois, so many links in this chat. Y'all are gonna have a lot of reading to do. The report that the Supreme Court Commission put out, so you can read their findings directly as well.
So I have another question here for you, Matt and Adrienne. And also in that pretrial report that came out for the Illinois Supreme Court, they did talk about transparency, to your point, Adrienne, that we definitely need transparency to know what 102 counties or 24 judicial courts are doing across the state, and share it and share what works. So somebody is asking, the terms bail and bond are used interchangeably. That's pretty basic, but can you share what that means?
Sure. So in Illinois, that 10% that I referred to earlier that people are paying to actually get free, that's the bond. And then the bail would be the full amount.
Okay.
So if a judge sets a $300,000 bail, I'm going to pay a $30,000 bond in order to be freed while my case is pending.
Okay. Somebody mentioned, or you mentioned that the percent of felonies after release, but a percentage of felonies after release, but there are two purposes to bond. And the second is to ensure people show up for their court dates. What percentage don't show up for their first court appearance?
So I saw that question come up, and I went digging for the stat. So the first year when bail reform went into effect in Cook County, you know, some 20,000 people that would have been jailed previously were released pretrial, and of those 20,000 people, 86% of them didn't just make it to their first court date, they made it to all of their court hearings. And then, you know, you add in that of that 14% that missed court, there's definitely people in those numbers that, you know, made an honest mistake and then were reasonably scared to go back. And so, you know, the organization I work for, the Chicago Community Bond Fund, we've paid bond for hundreds of people in the last few years that couldn't afford it. And then we support them while they fight their cases. And there've been a number of times where we've been contacted by somebody who made an honest mistake, and, you know, was terrified to show back up in court. And if they hadn't had the support of an advocacy organization, they may just have avoided coming back to court at all. Unfortunately, you know, we were able to work with their attorneys to help get them back to court in a way that didn't result in them being reincarcerated. But for most people, the fear of again, winding back up in jail is just so high. You know, I was actually talking to somebody a few days ago who was on an electronic monitor. They were on house arrest, and the home that they were staying in, they did not feel safe because somebody they were living with had become abusive. And they wanted to get moved to a different housing arrangement. And so the sheriff's office told them that they had to go back to the jail in order to get placed at a new housing arrangement on like an emergency basis. And they tried to reassure her that by going back in, she wasn't going to go back into custody. But, you know, just the fear of like that ultimately being the result was enough that she would, again, if there wasn't people to help mitigate that situation, they may not have gotten out of that dangerous situation, because again, you know, the jail is a dangerous place to be, especially right now with, like Adrienne had mentioned, I mean, 7 people incarcerated in the jail passed away in the last several months, and several hundred more became violently ill. And so, you know, even on a general day though, it's not a place for any person to be.
No, as I told you, I did do a visit there, and if I had stayed there overnight, I'd be dead. So one of the other team members that's involved in our pretrial is Kathy. Kathy, do you have a question that you want to share?
Yeah, I'd like to do a follow-on to the electronic monitoring. And it's a little bit of a follow-up to the question you just asked, which is that the whole bail premise is to protect the community against someone committing a crime while they're out, and also to make sure they show up for court. I'm curious as to how electronic monitoring is being used for the latter, which is ensuring people show up for court, or is electronic monitoring only being used for the most violent criminals? So I'm a little confused as to exactly its application, so I understand sort of the when and if it ought to be used at all. So
our organization, and I think our coalition as a whole, would argue that we don't believe electronic monitoring should be used at all. A lot of the harms that are caused by pretrial incarceration are replicated by electronic monitoring. A lot of people who've been on electronic monitoring that we've had the privilege of working with would argue that electronic monitoring isn't an alternative to incarceration. It's an alternative form of incarceration. And while being in somebody's own home is obviously dramatically better than being in a jail, again, a lot of the harms that we were talking about loss of job, housing, custody of your children, all of those things happen to people who are on electronic monitors. So in Cook County, the restrictions are fairly severe. You know, a person on an electronic monitor can't actually request movement to go to the grocery store. They can't request movement to go to CVS to pick up toothpaste. They can't go to the laundromat.
So excuse me, Matt, so it really is house arrest. It's not just monitoring them.
Correct. And so the only types of movement that people are granted on electronic monitoring in Cook County are to go to work. And even then, it really depends on what kind of job you have. If you're like a day laborer or a temp worker, you're not going to get movement. If you do, if you're an Uber driver, you're not driving Uber anymore. If you, if you do home repair, if you're a plumber or something and you're at somebody's different house every day doing repairs, they won't give you movement. You have to be somewhere where you're going to be every day, and they know where you're going to be. And You know, getting permission from your boss, I mean, to get movement. I mean, now you have to, even though, you know, it's illegal in Illinois to deny somebody employment due to a pending criminal case, most bosses don't want to be having to send your schedule to the sheriff's department once every other week. We've paid, actually, there's some people in Cook County that you can pay money to get off of electronic monitoring, which we've done. You know, we had a young person who lost 2 separate jobs because the sheriff's office kept showing up at their place of work to verify that they were there. And their boss said, look, like, I'm sorry, I don't want to let you go, but it looks really bad that the sheriffs are constantly, like, several times a week parked in front of our business, coming in to check on you. And most people in the neighborhood have no idea that they're here because you have this thing on your leg. But, you know, people are going to have ideas and people are going to talk. And so that young person lost their job, 20 years old, and was the only employed person in their house. And I just have real questions. You know, if we're talking about community safety, how does destabilizing a person's ability to make income, to take care of their family members, or to get health care? We had a gentleman that we bonded out of the jail who was terminally ill with cancer and was not getting sufficient treatment inside the jail. It took 4 months of him being on electronic monitoring before he was able to get back to a hospital to have his cancer checked on, because the hospital didn't want to send his paperwork to the sheriff's department because it was sharing medical records, and they wanted him to come in order to be able to verify that it was him to share the records. So it was like this catch-22, like, I need the hospital to put the paperwork in for me to get there, and they wouldn't do it. And this person actually lied to one of our volunteers one day and said, oh, I got the permission. And he got in this young person's car and he said, look, if you don't want to do this, you don't have to, but I lied to you. Like, I can't bear the idea that I'm not going to have this checked on. And, like, I just want to go, and I need to see a doctor. And fortunately, again, we were able to intervene and prevented that person from being taken back into custody. But somebody shouldn't have that kind of weight over their shoulders about whether or not they're going to be taken back to the jail for, you know, taking care of the most basic things. Not to mention,
I don't want to put words in your mouth, but it sounds like electronic monitoring, at least in Cook County, maybe, if not in all of Illinois, is in fact being used as a house arrest for just about anyone that's on it, and not simply for those people that are really a risk to the community.
So, yeah, I mean, since COVID-19, the pandemic hit, the number of people incarcerated in their homes on electronic monitoring has skyrocketed. So there were about 2,000 people on electronic monitoring in Cook County back in March. There's now over 3,000. And I think our organizations are very worried that we're implementing a new normal where we have little jails throughout the community, where community members are incarcerated in their own home. And I think the pandemic really put on display too that, you know, there was this mass review of people's bonds who were in the jail to try to get the number of people down when the virus first hit. And there were hundreds of people, in another report that I can link to that we just put out about the effect of the pandemic on the jail, but we documented that there were many people who got their bonds reviewed, who were given electronic monitoring so that they could get out of the jail during the pandemic. But had they had the $500, the $2,000 to pay their way out, they would have been able to be at home with their families without having this thing strapped to their ankle, and the risks that come along with being on house arrest. And so I think part of this is the narratives about crime that we see on TV every day. And I think there are judges that are reasonably afraid that if they make the decision and they release the quote unquote wrong person, and that is the unfortunate 1 in 40,000 cases where something horrible does happen, which we don't want to minimize, that bad things don't ever happen. But, you know, I think to the point that Adrienne was making at the end of the presentation, we can't allow, you know, a select number of cases to determine what happens to tens of thousands of people's pretrial freedom. So, you know, in effect, we can't lock up 40,000 people because of what 2 or 3 people might do. And yeah, I think, you know, if we think there are problems in our community that are exacerbated by poverty, putting people on electronic monitoring only effectively puts that on steroids.
Yeah.
Thanks, Matt. And one follow-on question. Can either you or Adrienne comment on the cost of monitoring versus incarceration?
So actually, Cook County gets $33 million for electronic monitoring, or otherwise like detention. And I think that's very general. I think that's under the sheriff and Cook County Jail's budget, but that's what we have found in the budget as of 2019, 2020.
What was that figure again, Adrienne?
33 million.
33 million. All right, and so I want to mention too, my understanding, there's two electronic monitoring. There's one through the judges, and then there's the other one through the sheriff. And aren't a lot of those people on electronic monitoring charged for having an electronic monitor on their ankle? Aren't there fees associated with that?
So not in Cook County, but in many other jurisdictions, people are charged for being on the monitor. And if you can't afford to make the payments to have the monitor, you're taken back into custody. So again, a wealth tax on whether or not a person is free.
So you can't afford to get out to pay a bail or bond, and you can't afford, okay, all right.
And I think I saw somebody in the chat had asked something about, bail money being a generator for wealth for the county. And, I think that's a disturbing thing that we've heard numerous times when we've talked to legislators about reforming the bail system, is in these questions come up about, well, where are we going to get the money to pay for our court system? And I think we need to take a long look in the mirror and ask if we're really comfortable with balancing the budget for the court system on the back of our poorest and most marginalized residents, which is really what we're doing right now. And, whether it's, we're looking at the sheriff's office or policing budgets, we're spending far more money on locking people up or criminalizing them through policing than we are on supportive services or even paying for our court system. And I think like a great display of that, I saw somebody ask a question earlier about public defenders and the results that people get when they have a PD. And public defenders, I think, often get a bad rap. To me, a lot of them are heroes. They are, they're doing this work for all the right reasons. They want to support people that can't afford an attorney. And unfortunately, we fund our state's attorneys' offices with much greater resources than public defenders get, which is, I think, in large part why a lot of the times they get a bad rap. They have to defend, in Cook County, at least 50 or so clients, whereas a state's attorney's focused on a small handful of individuals. I imagine we would have a much different criminal legal system if we were equally funding both of those departments.
You mean equal justice under the law?
What a novel idea.
Yeah. So I guess you can see the chat here, Matt. If I can, I'm going to try to wrap up now. I'm going to kind of combine one here, but does every county have its own bail bond system? And or does Cook County model exist in each county in Illinois? And how do bar associations, do they support money bail?
So to answer the first question, every county has its own bail system, but it's all handled the same. So there's I bonds, which I mentioned in the presentation, or recognizance bonds. That's where somebody doesn't have to pay money. There's the D bond, where the person pays a percentage of the bond. And then there's a thing called a C bond that doesn't really get used, where a person has to pay the full amount of the bond. So if it's a $50,000 bond, they actually owe $50,000, and that's the only way they can be released. And then the person can be denied bail. The system is basically the same in each county. Obviously, each county, though, runs their own system. And what the bail hearings look like, I think, vary throughout the county. There was legislation passed back in 2017 that mandated that every county courthouse in the state provide a public defender to somebody at their bail hearing, which alarmingly wasn't happening in nearly half of the courtrooms in our state, and is still not happening in many places because while that law was passed, there was nothing passed that was going to ensure the funding to make sure that there were the attorneys present in each of those.
Mandate.
Yep. Yeah, and I'm sorry, I think there was a second question.
Yeah, asking, do the bar associations support ending money bail?
I think that's a tricky one because many attorneys work for what's called a cash bond reimbursement. And so if somebody pays their bond, rather than taking monthly installments, sometimes people will sign over their bond money as a form of payment. And that acts as like a surety that, you know, the attorney knows that they'll get paid at the end of the case because the county's holding on to the money until the end of the case. And so I think there are a lot of defense attorneys that's how they make a living, is through collecting bond money as a form of payment. So some are not crazy about seeing that go away. But I definitely, just as like I think, you know, counties can find other ways to pay for these services that don't revolve around taking bond money from individuals. You know, defense attorneys can find other ways to ensure that they get paid. That's not to say all defense attorneys are against reforming the bail system. It's just, I think it's a complicated space for that reason, that it is a way that people get paid.
I hadn't heard that to pay the defense. I have heard it to fund the courts.
Yes, there are some situations where the court actually will, like in Cook County, decide that they're just taking the bond money at the end of the case, which I think, again, is really alarming because, you know, regardless of how the case resolves, you know, as I said before, many times this bond money isn't being put up by the individuals. And, you know, our organization pays typically up to about $5,000 to get an individual out of the jail. I can't tell you how many times I've had conversations with individuals who have sold their belongings to get loved ones out. Or I just talked to a woman the other day who actually caught COVID working in a nursing home back in April. She now has asthma and never had it before in her life. And her doctors have advised her not to return to work, but her son got arrested in August and she has put her life on the line by returning to work to help ensure that she can get her son out of jail. And I don't think these are situations we should be forcing people to make. And it's absolutely, to me, unconscionable that we're punishing the families and communities of individuals, and not even for things that people did, but for allegations, accusations.
Yeah, well, anyway, I thank you very much. You both have given us a lot to think about and just so much information. So just to mention to everybody, this has been recorded and then we make it available on our League of Women Voters Palatine area website in a couple of days. The beginning part will be taken off. But I have to thank you both so much for contributing and being here and so open with your information and answering the questions. And I thank everybody too that signed up and participating. This is a big deal. This is really a big deal, how it impacts lives and where we're spending our money. I mean, are we getting good outcomes? So I just keep coming back to that. So I hope it helps you to be better prepared for the consensus and the consensus questions. Every league is going to be hopefully doing it late December or early January. And if you want to do it early, that's okay. And we're going to do our Let's Talk, which is for just league members, and that'll be Monday, October 26th, and it'll be our team here talking about pretrial, cash bail, electronic monitoring. And thank you, everyone, and have a good night. And I think there's another debate on tonight, so maybe you're going to get over and check that one out too. But thank you, everybody, and have a good night.